Last year, we started a conversation where we were saying we need to apply our constitution faithfully, with fidelity and clarity. And that conversation was that a reading of our constitution requires that we hold our presidential and general elections in the 5th year, in August, second Tuesday of August in the 5th year. And today, the High Court of Kenya, sitting in Malindi, has affirmed that decision. This journey did not just start today. We went through a public discourse where we explained to the Kenyan people, including the IEBC, what the Constitution provides as to when presidential elections are supposed to be held. We also did draw a parallel comparison with the 2017 general elections, which were held on the second Tuesday of August in the 5th year. After this public conversation and civic education, we did file a suit in court in May 2025 before the Supreme Court. The Supreme Court of Kenya took time to hear our application to admit the petition, and they did come back to us and said, we don't need any permission to file a case before them, and we decided to file the case before the High Court in Malindi. The High Court in Malindi, we went on October 2025. It was over 1 year. And this interpretation of the law, the public discussion on it, the filing of the suits, gave IEBC adequate notice and invited them to interpret the Constitution and apply the law as it is. Which law, when faithfully applied, the presidential elections must be held this year on the 11th of August 2026. And that is what the court has today affirmed as the position. IEBC had erroneously moved on the premise that a president is elected to serve for 5 years, for a 5-year term. That was their argument in court, and the court told them, just like we had told them before, that there is no 5-year term anywhere in the law provided to the president, members of parliament, or the governors. They only serve until the next date of the elections. Then the president becomes a temporary incumbent. Members serve as temporary until the next parliament is sworn in. And has decided Swamoto to suspend the effect, to give IEBC time to organize its logistics and administrative components for the conduct of an election. I am also guided by the law, which says if an act is to be conducted on a specific date and it becomes impossible, administratively impossible, to conduct that act on that specific date, then the act must be done within the shortest time possible when it is possible to conduct that act. In this particular instance, the elections are to be held on the 11th of August 2026. But if, as the court has recognized, that it is impossible to conduct the elections next week on Tuesday, then IEBC has a duty to conduct the elections within the shortest time possible that is necessary to make the necessary logistics and administrative arrangements to conduct that elections. I am guided by the precedent that IEBC has shown, where when a vacancy has been declared for office of a member of parliament, IEBC, as per the Constitution and as per their own administrative arrangements, have been able to conduct elections within 60 days from the date of declaration of a vacancy. Our presidential elections, as confirmed in the Maina Kiai case, are constituency-based elections. We want to hear why IEBC cannot instigate the constituency election officers, the returning officers, to conduct elections within 60 days from the 11th of August 2026. If there be any other logistical arrangements beyond 60 days, they should make a case to the people of Kenya that we need an extra 60 over and above the 60 in the Constitution. They should conduct those elections within 120 days. That is what the Kenyan people can take as permissible. Anything beyond that, in my view, is an usurpation of the sovereign will of the people. And the legitimacy and the term of office of William Ruto as president, exercising a donated sovereign power of the people, lapses on the 10th of August 2026 midnight. Beyond that, we are moving to the next phase of a temporary president.
We as Safina Party want to give a great thank you to the High Court that has upheld our Constitution, and to the excellent work of our Deputy Party Leader, Willis Otieno. He has been excellent in court. He came out and tried to educate Kenyans, civic education about it. The last 1 year, he sought even discussions with IEBC, who ignored him. And now today we have a constitutional victory. And this we must be very, very thankful of as Kenyans. Let me say, William Ruto, your time is up. On Tuesday, you become nothing more than a president that has been given mandate by a court because of logistical issues, nothing else. Your term is over as of Tuesday. You are now then just given a template by a court. Your term has not been extended. That means if we were to read the Constitution, Article 134 describes a temporary president for such a circumstance. The first vote should have been on Tuesday, the 11th. After the first vote, you become a temporary president. And there are various things you can and you cannot do. Article 134 is very clear. So do not pretend to us you can make any decisions on our behalf anymore. You cannot. You cannot pretend to have a national dialogue. You have no legitimacy, William Ruto. You cannot even fire a minister after that day. Appoint a new officer after that day. We shall challenge you. Your time is up, and it was up long time ago. And you keep being reminded, you refuse to listen. This is a great day for Kenyans. Let us celebrate. Wakati sasa umefika ya Ruto kwenda nyumbani.